Okay. Good afternoon. We're going to get started. I think we're going to continue to be joined by people, but we'll get started now. I'm Anita Weinberg I co-direct the Civitas Child Law Center with Bruce Boyer there. On behalf of the center, our faculty and staff, and the law school, I want to welcome you to the start of the center's 30th anniversary celebration. 2 months before the Child Law Center launched in 1993, the American Bar Association published its report on the unmet legal needs of children and their families. It was titled, America's Children at Risk. One of its recommendations was to improve the training of lawyers who represent children. Around the same time as the report, the nation and legal profession were coming to grips with the reality that children are developmentally different than adults and in need of specialized representation and advocacy. 2 faculty members at the law school already were working to address this reality. Professor Diane Garrity and a former dean, Nina Appel. Along with alum Jeff Jacobs, they had the foresight and vision to establish an interdisciplinary program that would educate and train law students as litigators and advocates on behalf of children who were abused and neglected. And they also wanted students to understand enough about other disciplines to be able to work effectively with other professionals in the best interests of children. The center has grown since 1993. We've expanded to work on a broad range of issues related to education, the juvenile legal system, high conflict parenting disputes, immigration, and some children's health issues. And we focus on training students on systemic change as well as developing their litigation skills. We also train non-lawyers to understand a broad range of issues impacting children and families, especially through a legal lens. One goal when the center was established was to enable law students to learn about the most recent trends and developments in the field and to integrate that knowledge into how they respond to children and families. And that's what brings us to today's program. 30 years ago, Professor Garrity and her colleagues recognized that children and families were not being served by the system set up to respond to their needs. Today, we're still working within systems that have never achieved anything close to their purported aspirations. This afternoon, Professor Jane Spinak will discuss her evolution to deciding it is time to dismantle the juvenile court system because of its harms, and she will share her vision for building something new. We believe that this is an extremely challenging and important discussion, especially in the context of the growing calls to transform or abolish current approaches to working the child welfare and juvenile legal systems. It's relevant for the professional development of our students, to our work here at the center, and to the work of our colleagues and other advocates. This discussion also aligns with the law school's unique mission, which includes preparing graduates who will be ethical advocates for justice and equity, who will lead efforts to dismantle the legal, economic, political, and social structures that generate and sustain racism and all forms of oppression, and who will advance a rule of law that promotes social justice. We're glad that you're here to participate in this exploration and to engage in a challenging and critical conversation. Jane Spinak is the Edward Ross Arno, I should probably ask you how I pronounce that, clinical professor of law emerita at Columbia Law School. For 40 years, Jane directed clinical programs in family regulation at Columbia. She also served as the attorney in charge of the Juvenile Rights Division of the Legal Aid Society of New York. She was the founding chair of the board of the Center for Family Representation, and she co-chaired the Task Force on Family Court created by the New York County Lawyers Association. And these are only some of Jane's accomplishments, so they're ones that are specific to the book that she's going to be discussing. There are many more. Jane will be in conversation with Shalise Neal. And Shalise is a 2013 graduate of both Loyola's Law School and School of Social Work, and was a Civitas Child Law Fellow. She's a co-founder of Chicago Advocate Legal, where she now serves as supervising attorney and executive director. The mission for Chicago Advocate Legal, which is a not-for-profit law firm, is to provide community education on legal issues and systems, and to provide flat fee, income-based legal services to those who cannot afford them. Their work focuses on housing, family law, DCFS appeals, and the Preventive Law Initiative. Shalise also works as a research assistant on child trafficking issues at the Center for Human Rights of Children at the law school and facilitates a class on race and bias. And in addition, she is working on her doctorate in social work, which is focused on preventative lawyering. There's so much more to say about both Jane and Shalise, two people who I truly admire. But I think through their conversation, you'll pick up on what makes them so special and why they're here with us today. So thank you, Jane and Shalise.
You can hear me? All right. Well, Jane, it's an honor to be able to ask you these questions. I've always wanted to ask someone these questions. So this is a great opportunity. So just to start off, how did you come to write this book, and what did you learn during the process?
That is a $64,000 question. Thank you, Shalise. And thank you, Anita. I'm really happy to be here. I know many of your faculty and admire them and admire the center. So it's especially nice to be here. I began writing this book about a decade ago. As with many clinical professors, students got in the way, clients got in the way, years would go by when I didn't have much time to work on it. That turned out to be a good thing, because when I started, I thought I was going to write a book about how to reform the family court. For much of my career, I practiced in and taught about family court in both the juvenile legal system and what some of us call the family regulation system now, otherwise known as child welfare. And those reform efforts seemed to me to be useful at the time, but they didn't get very far. Every time there was a crisis in family court in New York, the response was, we just need more judges, or we just need more resources. And there was never the question of, you know, is this a system that works? Has it worked? Did it work at an earlier point in time and we should go back to that? Does it work? Are there things we can do to make it work better? And so when I began to write, I kept thinking family court or juvenile court, depending on where you live in this country, or children's court or domestic relations court, they're all, you know, overlapping and address the most serious issues about children and families. And so I thought, well, you know, if we just had more due process, if we just applied the law better, then it would be okay. And so I started looking historically. So obviously the original juvenile court was here in Chicago, and the women who really were essential for starting that court clearly felt deeply about treating children differently than adults. And I don't in any way suggest that we don't treat children differently than adults. I think part of my conclusion is we don't need a separate court for that. But the other reason why the original founders began this court was to fix people, to fix families, to fix children. And the immigrants who were flooding into the country at the beginning of the 20th century were very different than the earlier white settlers. They had different customs, they had different languages, they had different ways of doing things, and they were overwhelmingly poor. And so some of the ideas of the progressive reformers early on were very good. They were settlement houses, they were libraries and parks and kindergartens. But they also thought that the juvenile court was essential in trying to fix those families, treat children differently, less punitively, more therapeutically, and to turn them into, quote, proper Americans. So in my book, I call this the great idea. And because it does, doesn't it sound like a great idea? And so I went back to the beginning to look at that. I mean, yes, there are a couple of famous books that looked right at the beginning. Anthony Platt's book, later David Tannenhaus's book, to say, well, things weren't really quite that good and therapeutic turned into punitive pretty quickly. But there wasn't a look at, well, what happens over time? And I kept thinking, well, if I look over time, I'll find those places where the court worked and see what is it that made it work so that we could either recapture that or build on it. And much to my disappointment, there was never a time when the court worked well. And too often, historically, the answer was always, well, we don't have enough resources, we don't have enough judges. This is what we still say today. The last report on the New York court was exactly that. If we only had more resources, the court would work. And so then I moved into looking at, well, what did people say throughout the century? And remarkably, the critiques are very much the critiques of today. Those early women in Chicago, including Julia Lathrop, who became the first director of the Children's Bureau, the first woman to direct any federal agency, and the other women she worked with, they noted very early on that poverty was the main reason why so many families were finding themselves in juvenile court. But they also identified very early, much earlier than I had ever imagined, how racist the system was. I mean, they were identifying then that the disproportionality, they didn't use those terms then, but the disproportionality of Black children in the court was clear. The punitiveness against Black children and families was greater, and that what I guess I found most amazing was that their recommendations were the same recommendations we're making today. The supports for families need to be community-based. We need to recognize the racism and the segregation for these families. We need to recognize that they don't have the same opportunities. They don't have the same housing opportunities. employment opportunities. In 1920, there were 40 kindergartens for Black children in the entire country. And these were the kinds of reports that they were recognizing really early on. So it isn't like, we figured out something 124 years later. They were saying the same things. We should move things out of family court or juvenile court into the communities. And I'll say one more thing about that, and that is the other thing that I found through the century was who was pushing back against that. And it was overwhelmingly the judges. They kept saying, we don't get it right all the time, but we're better than any other alternative. Or, yes, it's important for there to be community services, but you need to have the hand of the judge who's going to make sure this child goes to probation meetings or this mother takes care of her child. And so the judges became, I would say, the strongest, not only champions of their court, but also, the ones who pushed back the most about losing any jurisdiction over the people who came to the court. And what I think, I guess one more thing, is that it's important to recognize that at the very beginning, there wasn't really a distinction between delinquency, which was both children allegedly breaking the law and children misbehaving, what we now call status offenses, and dependency. And all three of them were seen in a very interrelated way. You didn't need to have a cause of action to bring someone into court. You just brought them in because you thought they were breaking the law, or you thought they weren't listening to their parents, or you thought this mother wasn't taking care of her children. And so that expansive idea that you could bring families in for these interlocking reasons meant that the court had tremendous jurisdiction. And that is in large part why the judges continued to push back against losing any of that jurisdiction.
Thank you for sharing that. I think it was very helpful to lay the historical context the way that you did, and how that led to calling for abolition of the system instead. Now, you did touch on this a little bit, and I would like to go back to it, just because as someone who read the book, but also as a Black woman, I would say that it was tough reading those chapters on disproportionate impact, racism, and how Black families were treated. Not that I wasn't aware so much, but we hear it all the time. All the time about the disproportionate impact, and we see it. Those of us who have been in the systems, whether professionally or personally, we see it. How do we address that going forward, and how do we lean into it the way you did in your book? You were very honest about, how you felt working in the system. You were very honest about what your thoughts were. How do we lean into that, especially those who maybe aren't minorities or aren't someone who's experienced poverty or something like that?
Well, I was both very aware of how, while I was writing the book, I was really depressed about any number of times, in large part because from a place really of privilege. I'm a law professor, I'm a white woman, I have a lot of, even though I have worked in this system and have throughout my career gotten depressed about what happened to my overwhelmingly clients of color. I think I felt the worst knowing the history in so much more detail that we, I think we all suffer a little from presentism, like this is happening now. And we don't learn enough from history. And I felt I had not learned enough from history until I started going down these rabbit holes. And it made me far more not aware. I mean, certainly, was always aware of the impact of these systems on my clients and on their families, but it made me much more radicalized in the idea that this is not a system that can be fixed, that that all of the attempts to fix it have failed, and they weren't traditionally radical attempts. So particularly in the second half of the 20th century. So let me say a couple of things. One is that those reports that I talked about earlier, they were coming both from some courts, like in New York. I was really surprised. These two Irish judges kept saying, this system is not working for the Black families in New York, and we need to do something about it. And the reports that they had produced or had produced were all about what needs to happen in communities. And those kept being repeated through the first half of the 20th century. And I was pretty surprised to find that. But in the second half, when I think we were grappling much more openly in the civil rights era and had both some presidents and also a Supreme Court willing to look harder at what was wrong here. They were saying, so the Criminal Commission of Lyndon Johnson, I always get the title wrong, so I won't try. But it had a task force on juvenile justice, and both the commission and the task force basically said the juvenile court is a disaster. So these task force are, the most prominent people in the system, the most prominent scholars of the time. They weren't particularly radical. And they're looking at the court and saying, the court is a disaster. It doesn't work. What we need to do is to shrink it. We should not be bringing children in who are misbehaving but not breaking the law. We should be trying as much as possible to support children and families in the community. We should not be, we should give kids a lot of chances to mess up before we take them into court. So these were not radicals saying this, and yet it went nowhere. 10 years later, 10 to 15 years later, the Institute of Judicial Administration and the ABA create no, I'll step back because I want to make sure the chronology is correct. So then you get the Supreme Court basically saying about the juvenile court in several cases. The one you probably are most familiar with is in Ray Galt, where the court is saying that Gerald Galt, who allegedly made a lewd phone call without a lawyer, without a petition, without notice to his parents, without any evidence, the judge decided he made that lewd phone call and he should go off to the Arizona Reform School for the next 6 years. He was lucky because a woman lawyer who worked with the ACLU, Amalia Lewis, got the ACLU involved, went all the way up to the Supreme Court, and Justice Fortas basically said that, that children like Gerald get the worst of both worlds. They don't get the benevolence that the court is supposed to have, and they don't get the due process that you're supposed to have in a criminal proceeding. And so created a standard of fundamental fairness for youth charged with crimes, and in Gerald's case said, a right to counsel. Because they said they had the right to counsel, and the Johnson administration had issued this report, the juvenile court judges were up in arms. One judge said it was like a bomb on the court. The National Council of Juvenile Court Judges said they issued a resolution saying no more of our jurisdiction should be taken away from us. They reluctantly acknowledged that maybe lawyers were necessary, but otherwise don't mess with us. And then 10 years later, the ABA and the Institute of Judicial Administration, because the court had said there are some due process rights for kids, issued standards for what that meant. And there were originally 23 volumes. One of them, they just decided about education was too tangential to what they were doing. I'm not sure that's true, but that's what they decided. One volume never was completed, and I'll talk about that later. That volume was the one on child maltreatment. And in part, it was never presented to the ABA's House of Delegates because the family court judges were so afraid that they were going to lose some of their jurisdiction. And one volume was, quote, tabled. And that was the volume on non-criminal misbehavior. And it was because it was too controversial, the idea that you would take these kids out of court. So I tell that story in large part to say, what I'm saying today is not very radical. If you've got presidential commissions saying it, and the American Bar Association saying it, and even the Supreme Court saying this system is not working, it's not such a radical idea. But I do think, and there was a recognition in each of the, in the Supreme Court decisions, though not as much of a recognition as there needed to be of how disproportionate this terrible system was on Black children and families. but it was always there. And so it just seems to me that that we should not be, you should not be reading this today and feeling like, yeah, well, I know this. Don't we all know this? Either because we've experienced it ourselves or we have been in systems that experience this. So why does this have to be written about over and over again? And so, yeah, it's very depressing. And if it's depressing for me, it's much more depressing for the people who it's had the greatest impact and effectiveness, who have been affected the most. And as we know today, it's intergenerational trauma. It's not just, this happens to a child or a family at this moment in time, but things can get better. We know now that this kind of trauma is intergenerational. And so we're just allowing it to continue.
For that and for laying the groundwork for how historically these families have been in these systems and then present, and yes, intergenerational. I recall having a case where a mom said that she had been in foster care, her grandmother had been in foster care, and she was trying to get her daughter out of foster care. And I know that many of us have had instances of that as well. And hopefully in 10 or 20 years, we are not reading about this kind of disproportionate impact again. So you advocate
From your mouth to God's ears.
Yes, absolutely. You advocate for the abolishment of family court, systems of surveillance, punishment, family policing, and replacing that with meaningful community developed based solutions. So this kind of question is a little bit twofold. One, what would that look like? And two, how does that kind of go opposite to what we have seen played out in lower income communities, which is disinvestment, lots and lots and lots and lots of disinvestment, to the point where, at least in Chicago, we have lost a huge number of Black families. It's been a number of years now, but there was a period where there are a huge number of school closings. So what does it look like to invest in communities so that we can abolish the court in the face of ongoing disinvestment?
Well, the other thing that happened during this 10 years that I was working on the book is that abolition became possible to talk about. Abolition, not just tearing down, but abolition as a mindset for how do we do things differently. And, in New York, where I live, but in other parts of the country too, the young people who have been impacted by this system, and the parents who have been impacted by this system and their families have increasingly moved from being the occasional token on a panel to being at the center of change. And that has been I have been working in this system for 45 years. And that transformation to me has been the greatest change. That first, the voices of young people, and then the voices of parents, and then the broader voices of families have, it's kind of been this development that has said to professionals, you haven't led very well. Maybe sometimes you've meant well. I hope most of the time, I hope I meant well, though, as you mentioned, I talk about mistakes that I have made in my own career in this book. But nothing has changed. So I have had those intergenerational clients as well. And so this difference, Professor Weinberg and I, how long ago did that session? Pre-COVID, right? That we did a session with several activists in Chicago, along with another colleague of ours, to talk about this change that was really happening I don't even always want to refer to them as clients anymore, but people that we have represented, both finding and using their voices as a first step toward becoming real advocates and activists. And that for me was a real change, because it required me to step back, to, adopt what I think Lonnie Guinier and Gerald Torres, two famous law professors, called demos prudence, the idea that lawyers should be partners with the people that they represent, and that they also need to be led by the people that they represent. And in places around the country, that's actually happening. And for me, the solutions, like how do we go from a structured court system, a structured family regulation and juvenile legal system, to something that is far more community-based, has to come from those communities. I mean, we have to be, for those of us who are, quote, professional, we have to be ready to say, how can I be a part of this change, but not leading this change? How is my role to be different? And that's, and I also think that comes about in two ways. In my representation, I've taught about client-centered representation for a long time, but I think my thinking about what client-centered representation has changed, particularly in the last 15 years, to engage with my clients in ways that are collaborative in finding solutions and in deciding how is it that you want to move forward as a young person, as a parent, and how do we go about trying to do that? And so when I think about, shifting from from the disinvestment that you're talking about, and from these structures, a lot of it is about how do we learn from community activism? How did we learn from all the mutual aid that went on during the height of the pandemic? how do we learn from community-based organizations that are, you know, that we should be investing in. And I think that there are also, at the same time, some places where government investment has made a difference. Head Start is a great example. So I don't think we just want to eliminate. We want to figure out, well, how do we build on that? I mean, every Head Start program is supposed to have a parent advisory board. So it's not a leap to think about how do we do that in all kinds of community-based supports. So, you know, I have very specific ideas about how we move to shrink this system, and I have less. I think there are models for how community-based can work, but I also want to be careful about not imposing that and seeing myself more as someone in conversation with people in communities about how to make that change.
We have like, how many minutes? No minutes, but that's okay, because you did answer one of the last questions. And if you could give like 3 words, I know hard, but if you could give like 3 words to this, because you did speak on it a little bit, but we have law students here, we have professionals here. How, if someone is wanting to be not just a part of abolition, but also a partner with clients so that it's more collaborative, how would they go about doing that in their current position, whether it be student, professional, what have you?
Well, you know, I think the first thing is clients are the experts of their lives. And we too often, when they come to us, whether we are a social worker or a lawyer, and they come to us because they have a specific problem that does have to be solved, that doesn't define who they are. And I think for too long, perhaps in both professions, we define our clients by their problems as opposed to defining them by their strengths. We narrow our vision of who this person is. And I'm still amazed sometimes when I talk to clients about how much more they are than this way in which the legal system has defined them. And so I think openness to that is incredibly important, because you're much more likely to find creative solutions if you understand all of who your clients are. I think it's very important for lawyers and social workers and peer advocates to create ways to work together. So holistic, multidisciplinary representation, I think, has made the greatest difference in New York City in terms of the way in which clients relate to their lawyers, because they're much more relating to their lawyers either, and to their social workers, often through the peer advocates that work, who have gone through the system, who have that lived experience, and who allow clients to trust their lawyers and social workers who are representing them, because they say you can trust them. So I think pressing hard for multidisciplinary representation is a really important step. And you know, all of us with advanced degrees should be far more humble than we are. And to recognize how much we have been and continue to be part of the system. And our clients know that. So, you know, we have to build their trust. But I think if we were more honest with our clients about that need, we would do a better job, and we would then partner with families and communities to help them do what they want to do. Yes.
Thank you for that.
Can I say
Questions?
one more thing?
Yes.
There is a list in my book of the ways in which to make change that I just want to say that the series editor for my book, Nancy Dowd, who is also a family law professor, when she got to the end of the first part of the abolition chapter, where I say, these are the things that will shrink the system, she said, put it into a list. And then one of my colleagues, when she got the book, opened it up, made a copy of the list and put it up on her bulletin board. So there are very concrete recommendations there that we didn't have a chance to talk about, but so I just want you to be aware that it's not abstract. I have very specific ways that I think we can do this.
Yeah.